If merely a domestic ethnic minority, then Appleseed and what follows does not matter to you. You've already picked the boat and abandoned the canoe. Good luck to you continuing to find room on that boat, though. It will become a hard way to live, knowing that when the conditions are right, you can be lawfully, for example, money to be made, but for you being in the way, profit rights over human rights, and control by the majority are domestic matters you will be subjected to that the global community cannot interfere in. You will be on your own. Reminding that Section 35 Constitution Act 1982 doctrine, quote-unquote, protections, the terms of being lawfully pushed aside do not apply regarding FNLMA. Section 2, sub 3 reads, for greater certainty, neither the framework agreement nor this act is a land claims agreement referred to in Section 35 of the Constitution Act 1982. And that obviously Parliament can go in and change federal legislation as it chooses. Honor of the Crown? Well, the Crown did not force this. It was asked for, opted in. And once opted in, the federally created First Nation is subject to federal law. The framework agreement is done. It is now all about the FNLMA, and Canada can make new laws or amend old ones. And, well, maybe money is short. That's covered in the framework agreement. Section 28.1. Any amounts provided by Canada to the First Nations pursuant to funding arrangements in relation to First Nation land shall be paid out of such monies as may be appropriated by Parliament for this purpose. There is no money commitment in the FNLMA. There cannot be. It will always depend on parliamentary budget decisions, appropriations. You cannot take that to court. It is entirely within the discretion of the current government. Current governments cannot bind future governments when it comes to budgets or legislation. Quote, in Western Australia, where mining companies like billion-dollar profits exploiting Aboriginal land, the state government says it can no longer afford to support the homelands. Vulnerable populations, already denied the basic services most Australians take for granted, are on notice of dispossession. Yet again, Aboriginal leaders have warned of a new generation of displaced people and cultural genocide. Having insulted Indigenous Australians by declaring at a G20 breakfast for David Cameron that there was nothing but bush before the white man, currently Prime Minister Tony Abbott announced that his government would no longer honor the long-standing commitment to Aboriginal homelands. He sneered, "It's not the job of the taxpayers to subsidize lifestyle choices." The weapon used by Abbott and his redneck state and territorial counterparts is dispossession by abuse and propaganda, coercion and blackmail, such as his demand for a 99-year leasehold of Indigenous land in the Northern Territory in return for basic services, a land grab in all but name. The Minister for Indigenous Affairs, Nigel Scullion, refutes this, claiming, "This is about communities and what communities want. In fact, there has been only the co-option of a few." The reason is an extreme doctrine that evokes the punitive campaigns of the early 20th century chief protector of Aborigines, such as the fanatic A.O. Neville, who decreed that the first Australians assimilate to extinction. Influenced by the same eugenics movement that inspired the Nazis, Queensland's Protection Acts were a model for South African apartheid. Today, the same dogma and racism are threaded throughout anthropology, politics, the bureaucracy, and the media. "We are civilized, they are not," wrote the acclaimed Australian historian Russell Ward 2 generations ago. The spirit is unchanged. In 2013, the former prisons minister, Margaret Quirk, told me that the state was racking and stacking Aboriginal prisoners. When I asked what she meant, she said, "It's warehousing." John Pilger, Australia again wages war on its own people. Truth Out, April 23, 2015. The Crown Book British Columbia judge said a similar thing when I put Simano on the stand to provide evidence of the nature and purpose of religious hunting for longhouse initiatives for purposes of my client's defense. They had been charged with unlawful hunting. Simano left a legacy that includes standing up the longhouses and reviving the teachings that he carried all along the west coast of Turtle Island. How do I know this is not just a lifestyle choice? I really did not understand his question. The judge laughed and said, like Weight Watchers, a diet choice. He thought himself very clever.